Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Today, illusory consideration and its impacts. Okay, 3 companies. We're going to name them A, B, C. Companies B and C are the sole shareholders in company A. Got it? Great. The 2 directors of company A are the 1 director of company B and the 1 director of company C. These are fiddly facts. I want you to be on top of them. Companies A, B, C. A is owned by B and C. Director of B and C are also directors of A. Yes? Okay. Shareholders agreement between each of the companies, between company A, B, and C. They enter into an agreement. The nature of it is that if all directors of A, so each of our natural persons in charge of these 2 entities here, if both of those natural persons in charge of A cause A to make a request for funding from B, then B must comply with that request for funding. I think you already know where this one's going. What happens is our director of C wants to cause A to make a request for funding from B. It wants A to get some money out of B. And the other director of A, remember, who is also in charge of B, says, not sure we'll be making that request, and does not cause A to request funding from B, which would automatically cause B to give that funding to A. That makes sense? So we've got this director, this natural person who's in control of this entity here, is in his capacity as director of this company, preventing a funding request from being made. So proceedings are commenced on the basis that the suggestion that B would provide this funding was illusory. It wasn't a real promise because, bang, as the facts had set out, any request for funding could be prevented by B's director in its capacity as A, in his capacity also as A's director, could render any such request ineffective. They say that means that B's consideration, the important part of the contract, the value that a party gives, was illusory, wasn't really there. What the court found was that was wrong. That actually B's promise to give funding if it gets the right kind of request from A, from both A's directors, was not illusory. It found that the fact that the director of A, who's also the director of B, could stand in the way of that request being made may constitute a breach of that director's duties to its company A. It may found a derivative action, Section 236 of the Corps Act, Section 232 of the Corps Act, depression suits, these sorts of things. But it did not mean that the consideration that B had given to A under that shareholders agreement, under that contract, had been illusory. Fiddly facts, guys. Hopefully that little adventure in the nature of a shareholders agreement and how requests for funding might be made and the roles of similar directors, similar boards between different entities helped you. Hope you got some value from it, and I look forward to joining you again soon for another coffee and another case note. Cheers.